Corpbiz.
Hello everyone, I am Yash Saxena and you are watching Corpbiz. In this video, I will share some information with you on relinquishment deed. A relinquishment deed is the legal document through which a legal heir gives up his or her legal rights to inherited property. The relinquishment deed transfers title when a person dies intestate. Intestate means if the person dies without making any will. For understanding this in more detail, you should know what are the main components of it. First is registration of deed. The relinquishment deed is an essential legal document that is mandatory to get registered at the concerned sub-registrar office under Section 17 of the Registration Act 1908. Second is legal rights. An heir can transfer or release his constitutional right of the inherited property through the relinquishment deed. Third, consideration. A relinquishment can be made for a valid consideration or even with no consideration. Fourth is irrevocable. Even if relinquishment deed is done without any consideration, it is meant that its release is irrevocable by nature. More than one person should own the property if in question for a valid relinquishment. But why this relinquishment deed is a good option than others? Let me tell you about a few benefits of it. First is seamless transfer. Second, secure transfer if no will. That means if the deceased individual does not leave a will, a relinquishment document aids in the transfer of property. Third, other heirs. A relinquishment deed is a legal document that allows legal heir to surrender ownership of the inherited property to the other legal heir. So, what are the documents required for a relinquishment deed? Legal documents of the property, registered documents, a written document stating intention, co-owner's detail, particulars required for a release deed, name, age and address of the releaser and the releasee, property description, details on consideration if any, Aadhaar card, ID proofs like DL, passports, etc. PAN card of both the parties for the execution of relinquishment deed. You will require 2 witnesses at the time of execution of relinquishment deed, other agreements which you might have entered into concerning the property. Other materials may need according to state requirements. As we have discussed the documents, now I must tell you about the most important thing, the procedure, so pay attention. Section 17 of the Registration Act of 1908 mandates that the relinquishment deed is registered. It's because the deed in issue is a legal document in which a legal heir transfers his constitutional rights in an inherited property to the other legal heir as a gesture of goodwill. The following are the steps comprised in the registration of a relinquishment deed. Those are as follows. Preparing a relinquishment deed is known to be very first step towards registration process. We advise you to consult a lawyer who can draft the deed as per your requirement. Second is the relinquishment deed has to be printed on a stamp paper of ₹100. Every detail should be mentioned in the deed of the relinquished property. If the deed is prepared, the next step is to submit before the sub-registrar of assurances within the jurisdiction where the property is situated. Afterwards, you have to pay the registration fee for its registration. Generally, it is somewhere between ₹100 to ₹250 in every state because the registration fee varies from state to state. On the fixed day of the deed's registration, both the parties and 2 witnesses have to get an appointment at the registrar's office. Get all the documents with you for the verification and registration process as per requirement. Registered relinquishment deed can be obtained after a week after the above listed procedure is done. A provision has been made under Section 31 of the Act, sanctioning the registering officer in cases where a person is physically disabled and cannot visit the sub-registrar office. It helps the physically disabled attend at the residence of any person desiring to present a relinquishment deed for registration. It must be noted that the unregistered relinquishment deed is not a valid deed and is not eligible in the court. A relinquishment deed is a legally binding contract whose conditions are essential to the transfer of property's existence. The relinquishment deed must be carefully drafted and ample time should be allocated to all the stages of the drafting and registration procedure. This is where Corpbiz comes in. You should contact our expert team for such advice and understand everything in detail. Once the process is started with all the requirements, Corpbiz legal representative will coordinate with the sub-registrar's office to safe and sound a date for the registration process. Also, you will acquire the first draft of your authorized document within a few business days. You can evaluate the document and intimate for the corrections in case of any modifications. So, if you like our video, please subscribe to our channel Corpbiz. Thank you.